Hello and welcome to the first episode of Death and Taxes, a weekly podcast by the private client team at Burgess Salmon. My name is Tim Williams and I'm a tax and trust lawyer in the private client team, and together with my tax and trust colleagues Guy Broadfield and Edward Hayes, we'll discuss a range of issues facing clients and professionals alike. Each episode will be joined by specialist lawyers from around the firm to bring you our views on important topics for private clients. In today's podcast, we'll be discussing the issues facing trustees in a recession, and Ed and I will be joined by Sarah Charteris-Black and Caroline Emsley from the firm's dispute resolutions team. Both Sarah and Caroline work on a broad range of contentious matters, but work extensively in relation to disputes involving trusts, wills, tax planning, and the administration of estates.
We wanted to talk today a little bit about the challenges facing trustees in this environment, and also, what their responsibilities are, what they need to be thinking about as the economic toll of the pandemic takes hold, but also a little bit about what beneficiaries can do in that context. So I thought it might be helpful to start with the trustee side, because Ed, you and I advise lots of trustee clients on when everything's going nice and smoothly, but lots of our trustee clients are finding that things aren't going quite as smoothly as planned. So in terms of general trustee responsibilities around investments, can Sarah and Caroline, can I ask you to talk a little bit about that?
Okay, well, I'll kick off. So essentially, trustees need to do more than just secure the trust assets. They need to manage them for the benefit of their beneficiaries. So they need to consider what investments are open to them, and in order to just grow the trust fund. So the starting point is generally to look at the very wide general power of investment under the Trustee Act, and then to consider that alongside the terms of the trust to determine just the scope of the investments which the trustees in each case are authorised to make. And then trustees who have the power to invest are required to invest prudently, so in accordance with their statutory duty of care, and they need to make sure, really, that the investments they're proposing to make are suitable, and they've considered the need to diversify the trust assets.
I think there's a division that I've seen certainly amongst clients between trusts, where you have a formal investment advisor covering this kind of thing, and you can see that it's all being professionally done, everyone's taking advice, and so if anyone ever asks in the future, you have a nice paper record that you can show to people. Yes. And trusts which have more of a legacy arrangement, where they were begun with a certain set of assets and no one's ever really questioned whether that's the right asset mix to have. There's some nostalgia or kind of emotional connection to the assets from the settlor or whoever. And first of all, obviously, you should look very carefully at the trust document to see whether you have some kind of exemption from the obligation to diversify. But even if you do, it is still important for trustees to actually consider what is right for their beneficiaries and not simply park it as an issue that's irrelevant to them. So,
absolutely.
Yeah, and some trustees might have a fund manager as well, for example. And I think the trustees would need to go further than just leaving things up to the fund manager. And actually, if the fund manager looks like they're making a particularly risky investment or have acted improperly, and you don't replace the fund manager, then there might be a bit of trouble there. So yeah, being active really rather than passive.
I think for those trustees who've never taken advice, there's a difficulty when markets take a bit of a tumble and things start to go into a downturn, because they are more at risk than perhaps people who've been relying on reasonable advice and who've been kind of keeping their advice paper trail up to date. They might be on the hook if assets start to fall, because they do have a responsibility to positively manage the assets. And whilst there might be a bit of a legacy of what the assets were and have always been under the trust, they do need to be constantly considering whether that is a suitable investment to have within the trust. And I think they can still take advice now as to whether the asset that they have is suitable. But they shouldn't, when things start to go downwards, they'll need to think quite carefully about bailing out if it is unsuitable, because I think falling markets sometimes expose things which were never suitable in the first place, and then they might be in a difficult position.
Yeah, market buoyancy can definitely cover up where the trustee might not have been as active as it maybe should have been. So you might get away with being a bit more passive, is what I mean, if your markets are buoyant. But at the moment, everything's falling.
And so if we had a trustee client who was looking at their portfolios right now and thinking, this isn't looking ideal, presumably...
Unless they're in the tech industry.
Presumably, the two options you always got available to you are, if you have been taking advice up to this point and you have been doing almost by the book, just keep doing that, because consistency of approach is often important for trustees to be able to demonstrate. And actually, you don't want to look as though you're suddenly panicking and throwing your investment strategy out the window. And if you don't have a previous track record on this particular point, so you don't have the historic record you can show to people that we have been taking advice, well, unfortunately, you need to do it as soon as possible. And probably you want to be transparent about your proposals with the relevant parties, so the settlor and the beneficiaries, to try and make sure you're taking them with you, and they're not going to try and argue you're doing something unreasonable in reaction to the current state of the market.
I think that's probably right. Yes, I think certainly there's a risk for trustees in that latter situation of trying to kind of jump ship and sell investments when asset values are low, unless they're bringing the settlor and the beneficiaries along with them. It's probably also worth mentioning that for those trustees who have always been taking investment advice along the way, they should look to their advisors now for clear advice on whether the assets that they have remain suitable. And if the investment advice is that their assets are no longer suitable, then I think trustees should be quite cautious in that circumstance as well. They don't want to be too quick to accept that advice and then bail out of assets without first exploring why what was previously suitable is now said to be unsuitable. And inevitably, as I said, falling markets might expose some investments which were never suitable in the first place. And it might be a situation where the trustees actually need to hold the investment advisors to account for any associated losses.
That's really helpful in the context of trustees with, say, an investment portfolio or a more mainstream portfolio, shall we say, of investments. What about trusts with either a single asset, a family trust that was set up to hold a family company, or a trust owning one significant asset alongside maybe smaller pots of other things? Are they in a more difficult position than trustees holding, say, a broader investment portfolio?
I think it would depend on the terms of the trust a bit there as well, because if the terms of the trust are requiring the trustee to invest in a particular family company, for example, a particular asset class, and then they do need to do that. And we've seen sort of trustees becoming a bit worried about that, haven't we, recently, Caroline?
Yeah, so particularly trustees of trusts specifically set up to hold family companies, so which aren't diversified and where those companies acted in sectors which have really suffered, so travel, hospitality, property, that kind of thing, then the trustees have been quite worried seeing the value of the assets fall and had concerns about their own potential liability. But I think the basic position is that if the trustee specifies what the trusts must be invested in, so it's invested in, as Sarah said, whether a specific stock or asset class, then the trustee won't then be liable if the value of that asset falls. Trustee might be more exposed, in fact, if during the turbulent times, key assets which have been held by families for generations are then suddenly sold.
Yeah, although it's probably worth just noting as well, if the terms of the trust give the trustee freedom to invest in a limited choice, so maybe not just free reign, but there is limited choice within that, then they'll probably need to justify why they've made choice A rather than choice C.
So if we'd say the best case scenario is that the trustee, even if the portfolio is not as valuable at the moment because of market conditions, if they can show that they've been taking advice and they have basically been complying with their fiduciary duties, then hopefully all will be good. It's even better if obviously you can have your key individuals from the family or whoever it is involved and supportive of the steps you're taking and the approach you're taking. But obviously, given what you, Caroline and Sarah do, we all know it doesn't always go that way. And we're all conscious that actually, both anecdotally and I think supported by the evidence that is available, we've seen an increase in the last few years in disputes. I mean, Tim and I see both trusts and estates where families are increasingly upset with the current arrangements, and the ever-increasing complexity of some of these arrangements, I think, is leading into some of that. The stats we have for this are a bit ad hoc, partly because they tend to come from freedom of information requests, so you kind of see them when someone gets a headline and not. But just a couple of examples, that back in 2017, there was a big headline in the FT saying disputes over family trust jumped 43% in a single year. That was referring specifically to cases that went to the High Court. So, of course, there's various explanations you could have for that, but I think it's that kind of stat backs up what most practitioners feel is their own experience in this area, that we are seeing more claims. And do you have a good steer for the kind of claims we're seeing? What are the nature of the lawsuits being filed?
Well, yeah, like you said, volatility in the market is going to cause investment loss. And if there's investment loss, you're going to have beneficiaries that are going to want to try and recoup that loss. And one way to do that is to make probably breach of trust claim against the trustee. I think the exact type of breach of trust claim would depend on the facts, but if we're talking about assets sort of plummeting over the pandemic, it might be failure to invest prudently or failure to replace a rubbish fund manager, taking risky investment strategies, not investing in accordance with the terms of the trust. So it would depend on the facts of the case, but definitely breach of trust claims is the general umbrella term.
And is the remedy that people are usually seeking the removal of the trust? Are the trustee? Are they always seeking restitution in terms of the making the trust good, as it were?
I think often the norm in a breach of trust claim, or what perhaps used to be the norm, would be a claim for an account. Whereas I think often now those claims are more structured as a claim essentially just looking for the trustee to reconstitute the trust for whatever has been lost, and interest on whatever has been lost normally as well, whether on a simple or compound interest basis.
So in that instance, let's say our beneficiaries have brought a claim because they're not happy for one reason or another. What protections can there be for trustees? Because we often see a trust deed with an exoneration clause in. Does that protect the trustees, or does a trustee sitting back and relying on their exoneration clause lull themselves into a false sense of security?
So I'm not sure that a trustee would ever want to sit back and rely on its exoneration clause, but they can be useful as a protection for trustee. In England, exoneration clauses can validly exempt trustees for liability for all breaches of trust except fraud, although the conduct which is exempted in each case will just depend on the terms of the exoneration clause in the trust deed. Generally, they're worded by reference to fraud, dishonesty, willful default, something similar to that. I think it's just worth bearing in mind with exoneration clauses that something which came out of the Court of Appeal's judgment in the recent case of SOFA is that cases against trustees can be based on inference, cases of dishonesty. And that means that if a case which overcomes the exoneration clause can be inferred from the facts which are pleaded against the trustee, then strikeout won't be available to the trustee. So I think that case has been seen by trustees as kind of opening the door a little bit for beneficiaries to set out claims based on inference. And I think it perhaps used to be thought that trustees who acted properly and in the best interest of the beneficiaries ought to have nothing to fear from claims of breach of trust. And perhaps that claim has rocked that view slightly. But I think the best possible defence to allegations like that is ensuring that they have a comprehensive paper trail of documents to demonstrate that the trustee did act properly and was acting with a reasonable belief that its actions were in the best interest of beneficiaries. That's generally the best way to ensure that beneficiaries won't be able to surmount an exoneration clause, and that the trustee will be able to defend itself quite quickly.
I think it's something that's often misunderstood, isn't it? The exact entitlement to documentation and the paper trail, as it were. So you need that paper trail, but best to be aware of who can access it and in what circumstances.
Yeah, definitely. And something we've seen actually more in recent months is beneficiaries asking to see that paper trail, and particularly in sort of in the topic of investments falling, they're asking to see things like monthly statements of assets, investment portfolios, potentially investment advice taken by trustees, valuations, and they do have a right to ask for that information, and I think they are increasingly doing so in recent times, perhaps understandably.
And is it worth clarifying, do all discretionary beneficiaries have that right? Because I think there's a conception amongst lots of people that the key beneficiaries might be allowed things, but actually someone who is named, even as a specifically named beneficiary, but who isn't really anticipated to benefit, might have different rights.
They all have a right to request that information. It is ultimately a matter of discretion for the trustee as to whether or not that information is disclosed, and there would always be a number of factors that trustees would ordinarily consider when exercising that discretion. The main question being, is this disclosure going to be in the interests of the proper administration of the trust? And you mentioned discretionary beneficiaries, Ed. That would be a factor that they might take into account, because if the beneficiary's only got a theoretical interest in the trust, then the trustee might want to be a bit more cautious about what it's disclosing and what information it's handing over to that beneficiary. But then it would also depend on whether or not we're talking about a closed class of discretionary beneficiaries or a really wide class.
But do you think it's fair to say that overall a court's going to expect, if a trustee receives a request for kind of what's relatively basic financial information, the starting point is going to be where you should be providing that unless you've got a good reason not to?
Absolutely, yeah. There'd have to be a pretty good justification, I think, when we're talking about financial information relating to the state of the trust, not to provide that.
It's something with my kind of GDPR and data protection hat on, looking at trustees' exposure from that angle, although there are good arguments you can make that actually the new data protection laws and access to information that way doesn't really undermine the existing trust law. I think it's symbolic of this general idea that people should be entitled to more information than maybe they've had in the past. And if at the very least trustees take that as, look, even if we have legal arguments we can put forward to possibly block this kind of thing, do we really want to be doing that? And what will fighting these kind of requests do for our relationship with these beneficiaries and settlors and the future prospects of more serious claims or disagreements?
That's absolutely right. You want to maintain a good relationship where possible with those beneficiaries and not to be acting in a way that could be perceived as difficult. I think trustees need to appreciate that, particularly in relation to financial information. In many cases, beneficiaries will very reasonably be asking for that information, and it would be unhelpful to try to kind of take every possible argument to refuse to provide it, and perhaps would just lead to suspicion, which in reality isn't necessary or in any way justified. But actually, if people are refusing to hand things over, that's generally the way things go.
Yeah, the classic nothing to hide principle of if you can show good practice, do so when you've got the opportunity.
Yes.
Well, guys, thank you so much for that. That's a really fascinating run through of the possible risks and possible reach that beneficiaries might take in the current climate. And before we're running out of time a little bit, but before we go, have either of you got some top tips for trustees and top tips for beneficiaries as to what they should be on the lookout for at the moment?
I think top tips for trustees would be just to keep your records in line, make sure you've got a record of everything, and you've also got things like financial information readily available. I think something we have seen is if the trustee is taking a bit of time to gather that information, you are in a particular contentious back for delaying or not actively managing the trust because it's taking time to gather. So I'd say make sure that the information is to hand so that you can hand that over and keep the relationship with the beneficiary as friendly.
Great. And Caroline, what about beneficiaries?
I think from a beneficiary perspective, my top tips would be to keep aggressive correspondence to a minimum. If there is something you want to see and you think you're entitled to see it, absolutely ask for it. Don't be afraid to ask for it. But I think it's best to approach things with an open mind on the assumption that the trustee isn't doing anything wrong. And if you can see from the documents that that's not the case, then absolutely consider your rights and remedies in that circumstance. But in the first instance, it's good to try to approach things in a collaborative and open and friendly manner, because actually that's probably the way that you're going to get the most information.
Well, thank you very much. Well, that's all we've got time for on death and taxes. Thank you very much to Sarah Charteris-Black and Caroline Emsley, and Ed and I will say goodbye until next time.
Thank you.
Thanks for having us. Bye.
Bye.
Thanks again for listening to Death and Taxes, a weekly podcast by the Burgess Salmon Private Client team. You can find out more about Burgess Salmon and our team at burgess-salmon.com or on our LinkedIn page. Our next episode will have Guy and I talking to our colleagues in the family law team about divorce, so don't forget to subscribe, and thanks again for listening.